member of the subcommittee for his opening remarks.
Thank you, Madam Chair. Today's hearing raises an issue of common interest to the members of this subcommittee. Does Chapter 11 treat employees and retirees fairly when a business in financial trouble seeks protection under the bankruptcy laws? While there is a shared common interest in the issues to be examined today, there's another shared common interest at stake. That interest is ensuring that businesses can recover and return to viability through a Chapter 11 reorganization. Today we'll hear from a panel of witnesses, the vast majority of which represent organized labor. We must be cognizant of the fact that there are additional interests at stake when a business is faced with financial trouble. Unfortunately, many of those interests are not represented here today at the witness table. A primary purpose of the nation's bankruptcy laws is to permit a failing company under court supervision to rehabilitate and reorganize its business by allowing it to relieve itself of the burden of oppressive debt and begin with a fresh start. This is a primary purpose because returning a company to financial health is preferred to forcing a company to liquidate. This nation's big businesses, the employers of the unions represented here today, employ tens of millions of workers, pay tens of billions of dollars in taxes, and keep this nation competitive in the global economy. Corporate bankruptcy is not a financial scam, nor is it a gimmick perpetuated by heartless big businesses seeking to avoid paying their bills. The organization process is encompassed in Chapter 11, allows troubled companies to keep their doors open, preserving jobs and continuing to give consumers access to their products. If companies are forced to liquidate, all stakeholders suffer. Employees will lose their jobs, retirees will lose their retirement benefits, and creditors and shareholders will have any potential recovery diminished or eliminated. Liquidation hurts suppliers, customers, taxing authorities, and local communities. Essential to the reorganization process is the ability of a troubled company to discharge its existing obligations. In some cases, part of those existing obligations are going to be labor legacy costs, including collective bargaining agreements, retiree medical benefits, and defined benefit pension plans. Section 1113 of the Bankruptcy Code allows a company in Chapter 11 to reject, as a last resort, a collective bargaining agreement. The company can reject a collective bargaining agreement under Section 1113 only if good faith bargaining between the troubled company and the union does not produce an agreement. The statutory prerequisites have been satisfied, and the Bankruptcy Court finds that the balance of the equities favors rejection. Section 1114 of the Bankruptcy Code makes similar provisions for the rejection of retiree medical benefits and pension plans. Rejection of a collective bargaining agreement, retiree medical benefits, or pension plans is not something to be taken lightly. But in many cases, such rejection is the only avenue of a failing company has to return to viability and maintain jobs. Chapter 11 seeks to reconcile equitably many interdependent interests, just like other chapters of the Bankruptcy Code, but the paramount aim of Chapter 11 is to save companies that can still be saved. To reach that aim, we will have to strike the right balance between competing interests. In the Bankruptcy Abuse Prevention and Consumer Protection Act, we largely, although not completely, left many of the issues to be discussed today alone. Chief among those reasons is that some believe that placing any further restrictions, especially an all-out prohibition on the termination of collective bargaining agreements or retiree benefits, might actually put parties in a far worse position than we currently have under the Bankruptcy Code. Another concern of further bankruptcy reform in these areas is that labor legacy costs are not really a bankruptcy problem. That is to say that the problems with labor legacy costs that come to the front at the bankruptcy stage were created well before the company was faced with bankruptcy and only arise when a company faces financial problems. We don't want to use the bankruptcy law to fix problems that are really the result of gaps in other areas of the law. Critics of the bankruptcy laws often complain that the bankruptcy laws are too easy on financially troubled companies. In some areas, this criticism may have some merit, and we on the subcommittee are committed to make sure that the bankruptcy system is not exploited. But it is important that we not overreact. Many of this country's major corporations, including some of those whose union representatives are before us today, are still in business because of the bankruptcy laws, including Sections 1113 and 1114, allowed them to reorganize. Moreover, many companies have moved away from the employee benefit practices that are at the heart of today's hearing. So while we in the minority come to this hearing with open minds and want to work to provide for fair treatment of the American worker and retiree, we also believe it is important that troubled businesses be able to reorganize, even if it means rejecting certain labor legacy costs. Let me just say, I look forward to hearing from today's witnesses. And in fact, we have some amazing people. I don't know, Mr. Trumka, you may not be aware, but I'm a big fan of yours. I worked in the coal industry during the time that you led the union there, and made some amazing progress, largely because your concern and the concern of the union was about mine safety and not necessarily numbers of jobs and optimizing that. And we've just recently had, as you are aware, of course, a tragedy in the area that I used to represent in Utah. This is an awful tragedy, but on the other hand, during the period of time we were trying to save those workers, we had 168 Chinese workers who were drowned because the Chinese don't build dikes that are sufficient to protect their workers. You are a huge reason why we have such a safe industry today, and we're going to take another look at mine safety as a result of this disaster, which I think is largely a function of local geologic factors that we didn't understand at the time that we did the mine plan. But I appreciate your being here today. Others of you might be interested that I actually worked my way through was a Teamster. I'm a registered Teamster. That said, the bankruptcy laws are complex, and they are amazingly robust and bipartisan. And so if we're going to do something with those laws to help on the issues that are before us today, we have to be very clear and very specific about what the opportunities are to improve the law. And I think you'll find that there's an openness to do that, although it was so difficult to get the Bankruptcy Reform Bill passed last Congress that I'm not sure anybody really wants to open it up unless we have some great clarity about how and why to do that. Thank you, Madam Chair. I yield back the balance of my time.
Thank the gentleman for his statement.